Okay, this is Great Lakes Wine and Spirits LLC versus War Room Ventures LLC, docket number 20-277 CB. This is the time set for hearing on proposed intervener Bonnie Doon Winery Inc.'s motion for intervention and joinder. And before we begin, I'll take appearances. I guess we'll start with moving party appearance for the record, please.
Good afternoon, Judge. James Cresta appearing on behalf of Bonnie Doon Winery.
Good afternoon, Your Honor. Curtis Hadley on behalf of the plaintiff and counter-defendant Great Lakes. As noted, Richard Lopez is a client representative. He's on the Zoom call and will keep muted during the
That's fine.
hearing.
Perfectly okay. Okay, go ahead, Mr. Cresta, your motion.
Thank you, Judge. So Bonnie Doon Winery has moved this court to intervene in this action. Judge, we believe that we attached at Exhibit A what we fashioned as a first amended complaint, which includes both claims on behalf of War Room Ventures, which was the original defendant, counter plaintiff in this action, and now a new party, which is Bonnie Doon, which is we are also representing, recently retained, and they are moving for this action because, quite frankly, their claims are near identical to those of the counterclaim that's already existing in this case, including allegations that Great Lakes failed to perform and breached their agreement. And so, Judge, it's our position that these two actions should be heard together. And it makes sense that they be heard in this forum before you, considering that there are going to be overlapping facts and law. And ultimately, any decision that's rendered in this proceeding is going to have an effect on Bonnie Doon's claims against Great Lakes.
Okay, I have a question. And I feel like this might be a dumb question, but I'm going to ask it anyway. You were asking for intervention and joinder. Do you have to have them both, or are they in the alternative?
Well, Judge, that's a good question. You know, we did prepare this motion asking for both, but I guess our primary argument is under MCR 2.209. Claiming to intervene as a matter of right. And I think in the alternative, we also moved under MCR 2.206A1 as a permissive joinder. So, Judge, I don't know if we need both. So I think we did argue those in the alternative.
Okay, I guess it wasn't a dumb question then.
Definitely not.
All right. Okay, Mr. Hadley, you can go ahead, please.
Thank you, Your Honor. We oppose the motion based on futility and lack of timeliness. As I've laid out in my response brief and actually in our answer and affirmative defenses to the original counterclaim, this proposed amended counterclaim that's been filed now or that's been proposed on behalf of Bonnie Doon and on behalf of War Room seeks to make a claim based on contract and tort. But we are dealing here with a highly regulated field of distribution of wine, which is regulated in Michigan as part of the three-tier system. And as I pointed out, there is a statute sometimes referred to as the Wine Franchise Law, Section 1305 of the Liquor Control Code. And it specifically limits what a supplier can do in terms of a remedy for alleged non-performance by a wholesaler. Now, let me just say, before I continue my argument, Great Lakes absolutely denies any performance issues as it relates to Bonnie Doon, but accepting what's been alleged for the sake of argument, there simply is no cause of action for a supplier to just sue their wholesaler for breach of contract or for tortious interference or for anything else. The remedy under Section 305 is that it's statute number 436.1305. it's section 305 of the Liquor Control Code. It is that the supplier gives notice, written notice, there's an opportunity for corrective action, and if certain requirements are met by the supplier, at that point, the supplier has a remedy, but not in any other context. So the idea that Bonnie Doon, a longtime supplier, over 20 years, a supplier of Bonnie Doon wines, and as I mentioned, Great Lakes has, up until January of last year, was the exclusive distributor of Bonnie Doon wines in Michigan. So now the idea that Bonnie Doon, after they've sold the company, can just file a lawsuit as if this were about cheese or milk or something, it doesn't work. It's a regulated field. They have a remedy. They never chose to exercise it. And in fact, they never even really had any complaints that were material. So this is, in one sense, it's a request to amend a pleading, which is subject to the futility rules. And furthermore, even in the context of intervention, I cited to the court case law that basically says if the proposed intervention would plead a futile claim, then it's not, then the court is proper to deny it. As to timeliness, the case has been pending since last summer. I believe it's been pending for 10 months. The court has amended the pretrial order by stipulation. We're now, discovery closes at the end of April. And, we're less than 2 months from that. Now we have a request to bring in a new party represented by the same attorneys that have represented War Room. And granted, maybe the relief or the cause of action is similar to what was pled in the original counterclaim, but this would actually require me to do double the amount of discovery. I would have to now look at depositions of Bonnie Doon representatives and so forth. So there is prejudice, and there's prejudice from the lack of timeliness. There's no reason that if Bonnie Doon thought that it really had a cause of action, that it couldn't have filed its own lawsuit earlier. So, Your Honor, those are the general reasons I'm asking for the court to deny the motion, but more specifically as it relates to the court rules that are cited, we certainly don't have intervention, a situation of intervention as of right under 2.209 because that intervention as of right indicates that it would be available if as a practical, if the disposition of the action may as a practical matter impair or impede the applicant's ability to protect the interest unless the applicant's interest is adequately represented by existing parties. And there's no indication that Bonnie Doon's, they're a California company. There's simply no indication that somehow they're going to be bound by merger and bar or by collateral estoppel by whatever ruling the court makes as to War Room. Bonnie Doon, if they really thought they had a claim, could file its own lawsuit. So the intervention as of right doesn't apply. And as to permissive intervention, we just think that it is untimely, and in fact, the court rule specifically says it must be on timely application. I did want to just bring one thing to the court's attention, Your Honor, and that's was cited on page 6 of my brief. And actually I cited to the Michigan Court Rules Practice, but it's making reference to a Michigan Supreme Court case called Ferndale versus Royal Oak Township. And it basically says the most important factor is whether intervention at the time requested will prejudice the existing parties to the case. Intervention may not be permitted where it will have the effect of retarding the principal action of delaying the trial or requiring the case to be reopened. The intervener must be diligent and may be prohibited from intervention by laches or if he or she delays for an unreasonable length of time after knowledge of the action. And so here we've had a case that's been pending for 10 months. The same attorney is proposed to represent both sides. If there's some allegation that somehow something I pled on behalf of Great Lakes caused Bonnie Doon to think it has a cause of action, you know, the pleadings as to the original counterclaim were back last summer in July, or maybe my response was filed either in July or August. So, you know, I think that there's really no reason for the court to grant intervention. As far as joinder, I briefed that, Your Honor. I think it does seem to be presented as an alternative argument, but on the other hand, the joinder rules joinder that's for a party that's essential doesn't seem to apply to a counterclaim. So it doesn't seem to say that a counter plaintiff can be added to the case by way of joinder. But even regardless of that, let me just get the court rule in front of me here. So 2.205 is the first rule that they rely on. And so it basically says that joinder is permitted if the presence of this proposed added party in the action is essential to permit the court to render complete relief. Essential to permit the court to render complete relief. That's in 2.205A, necessary joinder. And there's been really no showing of that. So whatever rights Bonnie Doon had as a former supplier, it's not necessary that they be a party for the court to decide this case as it relates to the rights of Great Lakes and War Room. So we feel that 2.205 is not met. The second rule that's cited is permissive joinder of 2.206, and again, that is discretionary with the court, but given the untimeliness of it and the fact that the cause of action is basically not sustainable anyway, Your Honor, we would ask the court to deny the motion and let this case proceed. We are, you know, my next action once discovery is completed will be to file a motion for summary disposition based on Section 305 as to both the complaint and the counterclaim. And I do want to wait till discovery is completed before filing that. But it just seems at this point that it will delay this action in a way that is unnecessary and is not really appropriate. If the court decides to allow this amended pleading to be filed, we obviously would need an amendment of the pretrial order to extend some dates. Thank you, Your Honor.
All right, thank you. Mr. Cresta, do you want the last word here?
Yes, thank you, Judge. Now I'll address really two primary things. One is Great Lakes' position that Section 305 somehow renders this counterclaim futile, which is simply not true. And then I'll address the timeliness argument raised. Judge, if you go and you look at Section 305, it relates to termination of an agreement. It's not as Great Lakes says it is. Great Lakes tells the court it provides the sole dispute resolution means for the parties. That is absolutely not what the statute says at all in Section 305. So Section 305 relates specifically to terminating an agreement between the parties. And it does give steps and expectations for how to do that. It doesn't discuss breach of the agreement, failure to perform the agreement. Bonnie Doon and Great Lakes had a contractual relationship for approximately 20 years, Judge. Bonnie Doon never terminated the agreement. There's no dispute about that. And so Section 305 is utterly inapplicable here. Judge, I would direct your attention to Section 28, just a bit further down that statute, where it does provide that a civil action can be brought to address breach of the agreement or non-performance. It's Section 28 that applies here, not Section 305. And Judge, you don't even have to get to that argument today, because Great Lakes is essentially just argued a C8 motion, but that's not what we're here to discuss today. This is a very limited motion, okay, to intervene in this action, because Bonnie Doon has claims against Great Lakes, and it's going to bring those claims either here or in a separate action. And at that time, Mr. Hadley can file a C8 motion if he'd like to and claim that Section 305 precludes that. I think that motion will be denied, but he's free to do that. But that's not what we're here for today. Judge, the second thing has to do with the timeliness, which Great Lakes has made a big deal out of the fact that this is somehow untimely. You know, we had and made a big deal out of the fact that, well, if Bonnie Doon wanted to bring this claim, it could have done this years ago. Well, that's right. It could have. It didn't. We have statute of limitations in place, and Bonnie Doon isn't trying to circumvent any statute of limitations that apply to their breach of contract claims. The fact of the matter is, though, they do have claims. They would now like to bring those claims. And those claims are identical to the claims in the counterclaim. Mr. Hadley said they're very similar. They're not similar, they're identical. Specifically, Judge, there's a claim here regarding P.F. Chang's restaurants in Michigan. Okay. And Bonnie Doon Wines had an agreement where their wines could be offered at P.F. Chang's, and they would actually be included on the pretty lucrative businesses. There are a lot of wines that would like to be on the P.F. Chang's printed menu. And Judge, there's a claim here that because of Great Lakes' failure to adequately staff and perform the Bonnie Doon's account, that there were problems with the P.F. Chang's account. That is just but one allegation that's contained both in War Room's counterclaim and is going to be included in Bonnie Doon's counterclaim. And it's the exact same set of facts. So you can see why having two separate actions involving these exact same breach of contract claims could be problematic. Now, I said I'd address the timeliness. While this case has been pending for quite a while, the fact is no depositions have been taken. Discovery still has about another 60 days, I believe, or so. And so while temporally it's been around for a long time, there's still things that have to be done. So, and I don't see any prejudice imposed on Great Lakes or any prejudice demonstrated by Great Lakes other than Mr. Hadley's claim that he'll have to do twice the amount of discovery, which I don't know if that's accurate, but regardless, I don't think that's prejudice. If Bonnie Doon brings a breach of contract claim in a separate action, that's going to be the same amount of discovery. Or if Bonnie Doon had brought this claim at the very beginning, it's the exact same. It makes no difference whether it was brought now or brought then. And Judge, the fact of the matter is, we became aware, it was Great Lakes' position that if War Room's counterclaims were true, in fact, that Great Lakes had breached, it became clear to us that their position is going to be, well, really, that's for Bonnie Doon. They're the ones who are injured, not you. You came in later. Well, when we learned of that, we made contact with Bonnie Doon to find out, well, why didn't you bring a claim? What are some of those claims? And to get some of the history. And they said, well, we would like to bring a claim. So, this is actually brought to the forefront because of Great Lakes' position, which is that War Room can't collect for the breaches that occurred previously. So, Judge, we believe that in order that there aren't conflicting results for identical contract claims arising out of the same nucleus of facts. We believe that these claims should be heard together, and we don't believe there's any prejudice here. And so we would ask that our motion be granted.
Okay, I first of all will briefly address this argument that Great Lakes, the plaintiff, makes about section 305 and the argument that there's an exclusive remedy under section 305. I did look at that. I've definitely formed an opinion on whether that is true or not. But I think Mr. Hadley just indicated a while back that he's going to be bringing a motion for summary disposition. And I want to avoid a situation where I take a argument that wasn't the main focus of the motion and perhaps not fully briefed and make an opinion on it, where I come back later then and some brilliant attorneys change my mind and I'm stuck. So I'm going to skip that. Because I don't think it's needed in order to rule on this case. And that is because I think that I can go right to the permissive intervention request by Bonnie Doon. And that requires, first of all, timeliness. The plaintiff says that it's not timely. Did I say permissive intervention? I think I meant to say permissive joinder. I'm gonna go right to permissive joinder, and this is under MCR 2.206. I don't see a timeliness in the rule, but I'm gonna address it anyway because I think it might be an overarching issue, and it certainly would be if we called this something in the nature of an amendment, which you could call it that. So the plaintiff says it's not timely, but timeliness is evaluated by the delay that it would cause to the original parties or delay to the trial. The most important factor when looking at delay in the case is whether there's prejudice to the original parties. So discovery is not complete until April 30th, and no depositions, as I understand it, have been conducted. And the proposed counterclaim would not add any new cause of action into this case. The plaintiff says that Bonnie Doon gives no reason why it didn't file suit earlier or ask to come into this case earlier. And I would say that it's the plaintiff that gives no explanation of how it would be prejudiced by the joinder at this stage of Bonnie Doon. The plaintiff has said that they'll have to do double discovery. I don't know if that's true or not. However, I would say that's not prejudice caused by an alleged lack of timeliness in bringing a motion to join in a case. That's just what happens when you have an added party, but it's not prejudice by delay. So I have to reject that argument. The permissive joinder rule requires under MCR 2.206 that there's two alternatives, and one of them is the joining parties' presence in the action will promote the convenient administration of justice. The plaintiff says, first of all, that the rule doesn't even apply to counter plaintiffs. I have to really reject that argument because the rule applies to plaintiffs, the rule applies to defendants. And I think anyone would be hard pressed to say that the rule is that comprehensive and yet it doesn't apply to a counter plaintiff. So I just have to reject that. And then with regard to whether Bonnie Doon's presence in the action will promote the convenient administration of justice, I think the plaintiff acknowledges that when the plaintiff says if Bonnie Doon thinks it has a claim, it can file its own lawsuit. Well, of course it can, But the convenient administration of justice would be to allow Bonnie Doon permissive joinder in this action to file Bonnie Doon's own counterclaim in this action. So for those reasons, I am going to grant Bonnie Doon's request for permissive joinder under MCR 2.206 and allow the filing of the counterclaim that's proposed by Bonnie Doon.
Thank you, Your Honor. Could we address the timing of the scheduling order at this point? Because I would anticipate either in lieu of an answer to the amended counter complaint or shortly thereafter that we would file a C8 motion as it relates to Bonnie Doon. The court might know that Bonnie Doon and War Room are in somewhat different circumstances here as it relates to Section 305, because War Room is asserting that it's not actually a successor supplier. Bonnie Doon, there's no question that they were the supplier. And so the issue is, can you sue under contract and tort your own wholesaler for their performance, or are you bound by Section 305's remedies? That's an issue that does seem to be a legal issue, and I would anticipate filing a motion as to the amended counterclaim for that, which means that in terms of discovery going forward, we will need more time.
Okay. Mr. Cresta?
Yeah, I don't object to extending any dates that Great Lakes feels need to be extended. Candidly, I don't, off the top of my head, know exactly the best way to do that, but I guess my proposal would be for counsel to perhaps speak off record and submit a stipulated order to the court once we've had a time to kind